Hello friends, welcome to our channel. Friends, today we will see MCQ of Evidence Act Part 4. Friends, watch our complete video, like it, share it, comment on it. Don't forget to subscribe our channel. So friends, we will see MCQ of Evidence Act with answer. Question number 151. In a reference made over a disputed matter to a third person, the declaration so made by that person shall be an evidence against the party making a reference by virtue of. Answer is option number C, section 20 of Evidence Act. Question number 152. Communication made without prejudice is protected. Answer is option number B, under section 23 of Evidence Act. Question number 153. Confession caused by endorsement, threat or promise is contained in. Answer is option number A, section 24 of Evidence Act. Question number 154. Section 24 of Evidence Act applies. Answer is option number D. Only A and B are correct. Option A, when the endorsement, threat or promise comes from a person in authority. Option B, when the endorsement is of a temporal kind. A and B are correct. Question number 155. A confession made to a police officer is inadmissible under. Answer is option number B, section 25 of Evidence Act. Question number 156. A confession to be inadmissible under section 25 of Evidence Act. Answer is option number C, may relate to the same crime or another crime. Question number 157. Which of the following is not given by section 25 of Evidence Act? Answer is option number D, all the above, means option A, confessions made to custom officer. Option B, confession made to a member of railway protection force. Option C, confession made to an officer under FERA, all the above. Question number 158. A retracted confession means, answer is option number C, cannot be made solely the basis of conviction unless the same is corroborated. Question number 159. A confession made by a person while in police custody is inadmissible as per. Answer is option number B, section 26 of Evidence Act. Question number 160. A confession made while in police custody inadmissible under section 26 of Evidence Act. Answer is option number C, if made in the presence of a magistrate. Question number 161. Section 27 controls. Answer is option number D, all the above, means option A, section 24 of Evidence Act. Option B, section 25 of Evidence Act. Option C, section 26 of Evidence Act, all the above. Section 162. Question number 162. Section 27 applies to. Answer is option number A, discovery of some fact which the police had not previously learned from other sources and was first derived from the information given by the accused. Question number 163. Under section 27 of Evidence Act, discovery of fact includes. Answer is option number C, both A and B, means option A, the object found. Option B, the place from where it is produced. Question number 164. Section 27 of Evidence Act applies. Answer is option number B, when the person giving information is an accused and is in police custody. Question number 165. Under section 27 of Evidence Act, answer is option number B, only that portion which distinctly relates to the discovery is admissible. Question number 166. Fact discovered in consequences of a joint information. Answer is option number A, are not admissible and cannot be used against any of the accused person. Question number 167. Confession of an accused is admissible against the other co-accused. Answer is option number C, under section 30 of Evidence Act. Question number 168. Confession of one accused is admissible against co-accused. Answer is option number A, if they are tried jointly for the same offences. Question number 169. Confession of co-accused not required to be an oath and cannot be tested by cross-examination. Answer is option number A, first, second and third are correct. Means first, is no evidence within the meaning of section 3 of Evidence Act and cannot be the foundation of a conviction. Second, the only limited use which can be made of confession of the co-accused is by way of furnishing an additional reason for believing such other evidence as exists. Third, it is a very weak type of evidence and is much weaker even than the evidence of an approver. First, second, third are correct. Question number 170. Necessity rule as to the admissibility of evidence is contained in. Answer is option number B, section 32 of Evidence Act. Question number 171. Necessity rule as to the admissibility of evidence is applicable when the maker of a statement. Answer is option number D, all the above. Means option A is dead or has become incapable of giving evidence. Option B is a person who can be found but his attendance cannot be procured without unreasonable delay or expenses. Option C is a person who cannot be found. All the above. Question number 172. Under section 32 of Evidence Act, a statement of a person who is dead to be admissible. Answer is option number A, must relate to the cause of his own death. Question number 173. The person whose statement is admitted under section 32 of Evidence Act. Answer is option number C, may or may not be competent to testify. Question number 174. A dying declaration is admissible. Answer is option number C, in civil as well as criminal proceeding both. Question number 175. A dying declaration means. Answer is option number A, can form the sole basis of conviction without any corroboration by independent evidence. Question number 176. Which of the following section of Indian Evidence Act extend the protection to an agent which section 130 Indian Evidence Act provides for a principal? Answer is option number C, section 131. Question number 177. A agrees absolutely in writing to pay B rupees 1000 on the 1st March 1873. At the same time, an oral agreement was made that the money should not be paid till 31st March, applying section 92 Indian Evidence Act. Answer is option number C, the oral agreement cannot be proved. Question number 178. Evidence may be given of fact in issue and relevant fact in which of the following section of the Indian Evidence Act? Answer is option number A, section 5. Question number 179. A suitor does not bring with him and have in readiness for production at the first hearing of the case a bond on which he relies. Applying section 5 Indian Evidence Act, what is the conclusion? Answer is option number C. This section does not enable him to produce the bond or prove its content at a subsequent stage of the proceedings otherwise than in accordance with the condition prescribed by the Code of Civil Procedure. Section 180. Section 35 read with section 74 Indian Evidence Act presupposes that. Answer is option number A. A document produced is really an extract from the official register. Question number 181. Additional evidence means. Answer is option number C. Evidence laid in appeal after the trial has closed in the lower court. It is a privilege allowed only under special circumstances. Question number 182. In which of the following cases did the apex court held that the practice of getting the affidavit of defense witnesses in advance amounted to an attempt aim at dissuading the witnesses from speaking the truth before the court. This type of interference in criminal justice should not be encouraged and was to be viewed seriously. The court deprecated this practice. Answer is option number B. Rachapalli Abdullah versus State of AP. Question number 183. Section 130 Indian Evidence Act protect a witness who is not a party to the suit in which he is called from producing. Answer is option number D. All of them means option A. Title deeds to any property. Option B. Any document in virtue of which he holds any property as pledge or mortgagee. Option C. Any document the production of which might tend to criminate him unless he has agreed in writing to produce such document. Question number 184. Section 81 Indian Evidence Act deals with which of the following documents which shall be presumed to be genuine. Answer is option number D. All of them means first gazette, second gazetteers, third newspaper or journals, fourth every document directed by any law to be kept by any person if that document is kept substantially in the form required by law and is produced from proper custody. Question number 185. The good faith of a sale by a son just come of age to a father is in question in a suit brought by the son applying section 111 Indian Evidence Act. Answer is option number C. The burden of proving the good faith of the transaction is on the father. Question number 186. The use of secondary evidence under section 33 Indian Evidence Act is limited to which of the following conditions? Answer is option number D. All of them means option A. If the proceeding was between the same parties or their representatives in interest. Option B. If the adverse party in the first proceeding had the right and opportunity to cross-examine. Option C. If the question in issue were substantially the same in the first as in the second proceeding. All of them. Question number 187. Under section 65 Indian Evidence Act, which of the following needs to be proved concerning secondary evidence? Answer is option number D. All of them means option A. Existence of a document. Option B. Condition of a document. Option C. Content of a document. Question number 188. What do you understand by deposition? Answer is option number D. Both A and B. Option A. It is party and voluntary. Option B. It is evidence given by witness under interrogatories, oral or written, and usually written down by an official person. Question number 189. When is an inquiry said to be judicial? Answer is option number A. If its object is to determine jural relation between one person and another or a group of persons or between him and the community in general. Question number 190. Which of the following are some of the instances of notifications or rules of which judicial notice was taken? Answer is option number D. All of them means first the army regulations and ordinances issued by the government of India. Second, notification of the appointment of a drug inspector under section 21 clause 1 of the Drugs Act 1940. Third, a rule made under the rule 225 of printing manual published by the government of Madras providing for return of old and obsolete stamps to government press on receipt of new ones. Fourth, a notification issued by the government declaring Malas to be socially and educationally backward class. Question number 191. Which of the following has been repealed by the Repealing Act 1938? Answer is option number B. Section 2 Indian Evidence Act. Question number 192. Which of the following is important to make the evidence of a witness relevant under section 50 Indian Evidence Act? Answer is option number D. Both A and B. Option A. The witness must have special means of knowledge with regard to existence of the disputed relationship either as a member of a family or otherwise. Option B. The witness must depose to his own conduct toward the person whose relationship is in dispute. Question number 193. Which of the following is true of section 48 Indian Evidence Act? Answer is option number D. All of them means option A. It deals with the opinion as to the existence of a general custom and rights when the court has to form an opinion as to its existence. Option B. The explanation to the section states that the custom and rights common to any considerable class of persons would also come within the expression general custom or right. Option C. It deals with oral evidence given in court by the person expressing the opinion. All of them. Question number 194. Which of the following proviso of the Indian Evidence Act enables the court to require the production of material things for its inspection? Answer is option number D. Proviso 2 of section 60. Question number 195. Which of the following maps are made under the authority of government? Answer is option number D. All of them means first survey maps, second Thagbast maps, third Chitas, fourth supreme position of maps. Question number 196. Which of the following section of Indian Evidence Act deals with admission not conclusive proof but may be stopped? Answer is option number B. Section 31. Question number 197. Which of the following section of Indian Evidence Act deals with fact bearing upon opinion of experts? Answer is option number A. Section 46. Question number 198. Which of the following section of Indian Evidence Act deals with oral evidence which must be direct? Answer is option number D. Section 60. Question number 199. Which of the following section of Indian Evidence Act deals with proof when attesting witness denies the execution? Answer is option number A. Section 71. Question number 200. Which of the following section of Indian Evidence Act deals with burden of proof as to ownership? Answer is option number C. Section 110. So friends, these are MCQ of Evidence Act. Thank you.